Kumar Singh.
Lordship,
Your Lordship, in this case, Your Lordship has directed to director to hear. This relates to the grant scale because, Your Lordship, there are various judgments about more than 20.
Who is Director of Secondary Education? Is he here?
Lordship.
Now you need to, can you just lower down your mask for a while if you're comfortable? What's your name?
Sir, I am Manoj Kumar, sir.
Mr. Manoj Kumar, you have read my earlier order.
Sir.
Now you need to explain to us. We will not hold you back today. You need to explain to us why are you adopting this pick and choose in the department. Don't say no because we have seen this.
Sir.
Don't say no because we have seen this, that whenever you get an order of the court, you pay him the ACP or the scale. If there is no order, you wait for the employees to approach the court and obtain an order. Why this?
Sir. Sir, I would like to clarify, sir. Okay. In the matters of appointment or financial matters, we are guided by the orders or circulars issued by General Administration Department and the Finance Department.
That's again you are getting back to the same old story. Now I think I had stated something in my order. Did I or did I not?
Yes, Lordship.
Just a minute. Just a minute. Let me have a look at my order. If I remember correctly, this
Yes,
is with
yes,
respect
this
to
is
some
there.
higher scale. Which order is that? Order dated?
Order before the last date order, Your Lordship, because on that day the director was not present, so time was taken, Your Lordship.
Yes, this is what I want you to address to. The order dated 29th of November 2021. Is that before you? Have you seen that order?
Sir, I have seen it.
Yeah.
We have filed the supplementary affidavit also.
You filed a supplementary.
Sir.
Let's see what is it. You're filing it today?
Lordship 20-20-12 को फाइल किया था.
20-12 को फाइल किया है.
Original copy is here, Lordship.
इसमें भी हुजूर वही स्टोरी है जो
You have given
yes, I have been given. The same thing is there, Your Lordship.
supplementary affidavit has been filed.
Supplementary
on behalf of the
counter
respondents.
affidavit, Lordship.
Supplementary counter affidavit has been filed on behalf of the respondent in the registry on so and so. The same is not on record. However, a hard copy of the same has been. Oh, you have not filed. You are filing. You have not filed. You are filing it.
Lordship already filed
No.
online.
This is affidavit petition. You must have filed it before the registry.
Registry online, Lordship.
Online.
Lordship.
ऐसे लिखे. The third supplementary affidavit has been filed today across the board. Let it be taken on record. Yes. What have you stated?
Here, the same stand which was in the counter affidavit, Your Lordship. They do not deny that there are various persons, even the juniors, about more than 100. They have been given a scale.
Just give me 1 minute, Mr. Amresh. What is the status of the civil review number 236 of 2019?
It is still pending, Lordship.
No, so far as your statement is concerned, in the affidavit that they have been appointed after the cutoff date of 2000, we are quite in tune with that. We are on the same page. There is no difficulty. What pains this court is that somebody else has been paid by virtue of an order of this court. Now, why this court should not pass an order? You have not been able to have that order passed in LPA modified or varied. And many such orders have been passed by single judges taking a reference of that order in LPA 167. Now, 167 also says that any process of appointment which was begun prior to the cutoff date and concluded after the cutoff date, that shall be treated to be one particular class where they would be treated as upper division clerks with the same scale, maybe lower division but the same scale. Now you have gone even further. Without the orders of the court, you have gone down further. Persons whose process of appointment began much after 2000, they have also been paid. I mean, this was the only question which you were required to answer. Now, why should this court perpetuate this kind of inequality? That's the refrain which this court has.
So this
Now,
was
you may say that these orders, these are misadventure by the district officials. We are not ready to accept that. Question is that if you can indulge in such misadventure, why should the court not follow what has been decided in LPA number 167 or thereafter? Now, why should I shut my eyes to it? And precisely for this reason, I had asked you to appear. Perhaps because of some preoccupation, you are not there on the last occasion. I sent him away. He was not in a position to tell us. Now, should you explain this? We will pass an order that there is no explanation whatsoever. So far as the legal position is concerned, you are absolutely right. There is no difficulty. I would not have called you. With the resolution of the government of demerging the cadre of lower division and upper division and making a special provision and cut-off date for the purposes of fixing the pay scale, you are absolutely justified. There is no difficulty. We will say that it is in consonance with law. But if you are in a position to give an affidavit, we will require it from you, even if you are not, that nobody whose appointment process began prior to 2000 or was appointed prior to 2000, I mean, nobody who has been appointed later than 2000 or whose appointment process has not begun prior to 2000, none of them are being paid that higher scale. We will accept your proposition hands down.
there was no direction from the directorate or the department to allow these cases where the process has begun earlier to that cutoff date, sir. It was completely. It was a completely wrong interpretation, or.
No, that doesn't satisfy me. We know that. We know that what you've done is correct in this, but what you've been doing in cases of others is something different. Now, what is your answer to this? If you can't, naturally, you can only explain the position of law. We'll be required to question the education secretary or the health secretary. I'm sorry, health secretary.
This is the case of
Education secretary. He must explain. We can't allow this thing to happen under my eyes and nose. You give an affidavit that nobody who has been appointed later than the cutoff date or the process begun later than the cutoff date has not been paid. We will shut this case.
Sir, as and when we came to know that the district officials are interpreting the Honorable Court's order in a wrong way, we have issued instructions and we are seeking information from them, and then we will be rectifying those mistakes also.
So you will be rectifying, so you rectify the mistake sequence wise. We are passing an order. We will say that this is, why should he face the brunt of his client? Now you have not taken a policy decision, you are seeking information. What information would you require? We are not asking you to take a knee-jerk reaction over this and ask for recovery of the amount or modification of such orders. But why shouldn't you give it to him?
Sir, prior to the order of Honorable Court in LPA 167, we have the claim of the petitioners which were put in the same footing. The claim was rejected by the Honorable Court, and
That
yeah.
you have said in so many words. Are we disputing that? When I say that I am on the same page, don't you realize that I understand that difficulty? But as a judge of the court, as a constitutional court, how do I shut my eyes to this fact that many others are, who would be sailing the same boat are being paid higher scale? आप या तो उनसे आप वापस लें, vary the order, you modify such orders, or give to them also.
Lordship in
And what is the conduct of the department? If these orders stare against the resolution of the government, where have you made an application before the Chief Justice that this order requires to be modified? Where have you filed an application? After review, where have you made efforts of getting this review petition decided?
Lordship,
You have not done anything. Now,
yes.
why should we not take it as an acquiescence, as maybe a collusive act that you people keep passing orders, the bench passes an order and then you blindly comply. You don't even object to it. And you don't file any application for review. And leaving a court which is giving due regard to your own resolution, absolutely helpless in these matters. No, you have not done anything for me to be satisfied that you have taken a good stand, you have taken a reasonable stand. No.
Lordship, LPN number 13303 of 2014 is passed after consideration of the LPA 167.
That's right. So therefore there are two.
And the different order.
Aap samajhiye, Mr. Madanji.
Lordship.
Please, we are aware of all that. Now, what is the rule of precedence? What is the rule of if there are if there are two judgments by benches of coequal strength, the one which is earlier in point of time is to be accepted. Now, where have you brought it to the notice of the Chief Justice that the dispute between two division bench judgment ought to be resolved? Have you done that? You have not. Why should we leave you at this? You are perpetuating this injustice. Mr. Counsel, what is your name? No, yeah, no, mask hata ke boliye. Please stand up. What is your name?
Sorry, my
No. I will tell you something. What is your name?
my lord, there are two.
No, what is your name, I am asking?
Ram Kishore Singh, my lord.
Mr. Ram Kishore Singh, when the court is making some observation or the person standing before the court is making something, you need not always shake your head like this. As if you are giving approval of what is being said or what is not being said. It distracts the attention of the court. And it is not necessary.
My lord, sorry.
You are quite agile in the courtroom, you are alive to the situation, but don't pick up this habit of unnecessarily, yes, no. It disturbs, it doesn't look nice, it looks very indecent. Right? When you are called upon, you answer. Yes.
Lordship, several orders have been passed by this Honorable Court in the light of the 167 LP number 1. And almost all the orders the state has filed the LP.
We have followed. You are repeating the same thing over and over again. We would direct for appearance of the Education Secretary, because we are not satisfied that you have taken any steps to remove this anomaly. You have not taken any steps to remove the anomaly, and you are repeating the same things over and over again. I have told you this is a matter of discomfiture for the court. which judgment to follow. And the court is not going to pass an order. We are referring the matter to the Chief Justice. Now give us all the decisions, liquid. If you have not done it, we will do it.
Your Lordship, there is another judgment also,
No, that's all right.
in which my learned friend has not given to your Lordship. I am giving your Lordship in that judgment, that is the division bench. In this case, your Lordship, even the accounts clerks, your Lordship, who were getting 3,000 has been granted. Your Lordship, kindly see this order also.
That's all, that's all right. We, in principle, we agree.
Otherwise, your Lordship, I am saying two things also, your Lordship.
Yes.
In the same district also, your Lordship, they are paying, of course. And your Lordship, one judgment I have already brought to in the writ petition.
I am sure even the Education Secretary will come and say the same thing what the Director is saying.
Your Lordship,
This
let come, your Lordship, because
this is
in one
this
case
is-
what happened,
this
your
is
Lordship,
ridiculous, I must say.
what my learned friend is saying, he has not done. I am producing, he has done it, your Lordship. He has done it. Your Lordship, kindly see, he is not saying that. Because I am saying that the wrong fact is being stated here, Lordship. Your Lordship, kindly see, this is the order dated 13/7/2001. I hope that,
Which document are you referring to?
yes, your Lordship, kindly see this one.
But that was a conditional order. Subject to
Your Lordship, he is saying, and another order, your Lordship, is the writ petition, in which also it is quoted, the director has directed.
No.
When I am saying,
Please don't interact
Yes,
with
yes.
him. You
Yes,
take
yes.
the submissions to the court.
file.
कंटेंट में जो ऑर्डर किया था तो करते हैं जो उसमें कंडीशनल
नहीं, वो तो
कंडीशनल
We can't find fault with this order. This is in pursuance to the directions passed by this court. We'd like to hear the Advocate General. Mr. Madanjit Kumar, you have explained, not that there is any difficulty in your explaining the issue. Before referring the matter to the division bench, from where it could go to the Chief Justice, we would like the Advocate General to assist us.
And in the writ petition also, your Lordship, there is, your Lordship, I am saying, even the junior person, even in the same district, they are getting. Your Lordship, I kindly see.
We can't possibly point an erring finger at the director for the reason that whenever it is convenient for him, he follows the judgment of LPA 167.
Yes.
Other times he follows some other judgment which he has annexed. I can understand his situation. His secretary should have taken care of this.
Your Lordship, in this case, your Lordship, I am saying, the order which I have, the order.
See, what I do is this. I will record my own observations. We will ask for the Advocate General, and you please communicate this interaction of the court to your secretary. One day we will be required to ask him. What will he do? He will also come and say that this order, this divergent opinion has to be resolved. That's all. But you are not taking any steps towards that. But anyway, let me pass an order.
I am saying, it was one thing just I am informing your Lordship. The order which I have communicated to your Lordship, this case also, even the your lordship, the chief
That's all right, we have understood, Mr. Amresh Kumar Singh. Where is the difficulty in understanding your
एक चीज कहना
submission?
चाह रहा था, उसमें जो चीफ सेक्रेटरी को ऑर्डर हुआ कि आप रिस्पॉन्ड करिए, तब इन्होंने इम्प्लीमेंट किया, तो उसमें भी चीफ सेक्रेटरी का वो नोटिस हुआ।
That's wrong. That's patently wrong. That is the whole difficulty. That's patently wrong. In fact, under the garb of that order, they are perpetuating something which is neither there in the resolution, nor is it fair on the part of others.
और अनेक्चर 9 सीरीज पे जो हम रीट में लगाए हुए हैं, इसमें भी डायरेक्टर के ऑर्डर से पेमेंट हुआ है। अब आज कह देते हैं, क्योंकि अब तो इनका कुछ दिन में ट्रांसफर हो जाएगा, इनको तो पता रहेगा।
Let us not talk like that. You're in a court of law where you are the officer of the court. He is an officer from the government.
No,
We have heard from him.
I'm not. I'm
We have heard
saying
from
about
him.
his difficulty, your lord.
That's all right. We have heard from him. If at all any observation has to be made, it has to be on the secretary of the department, not him. So we have just understood he is aware of the difficult position that he has been put into because of two divergent opinion of the division benches, and the efforts which should have been taken by him to have it resolved, they have not taken it. So let us see.
हाँ, आज
what
तक
happens.
सिविल रिव्यू डिस्पोजल हो जाता तो ये हो जाता तो उसको छोड़ दिए हैं अभी तक 19 से है हुजूर, आज तक यदि एक आज हम लोग 22 पे बोले
Therefore,
जाते
it is precisely for this reason that I am asking the Advocate General to come here. Because, see, the difficulty is this. Now, which judgment to follow? The resolution is absolutely clear in its import. Anybody who has been appointed after 2000 or whose appointment process began after 2000 is not entitled for the IRSK. It is as simple as night follows day. Only because of some observation in some case and the authorities blindly, following without understanding what the court wanted.
One thing I am from your lordship, they themselves have diluted. अकाउंट्स क्लर्क को उन्होंने दे दिया,
And there is difficulty.
भंडारपाल को दे दिया।
नहीं, अरे आप बात नहीं समझ रहे। You have to place yourself away from the facts of your case.
Yes, ठीक।
अभी आप अलग से देखिए। Now let us see where is that judgment where LPA number 167 has been discussed.
Yes, your lordship. I have your lordship given also in this today your lordship I have given in this or your lordship the LPA order has been discussed, and another I am giving your lordship two judgments. This is the two judgment, your lordship, in which after discussing your lordship both the orders LPA, the order has been passed. Two इसमें हुजूर फर्स्ट ऑर्डर में जो है कि दे आर थ्री पर्सन्स दे
Divergent नहीं है। एक सेकंड। LPA number 100 of 2012. Where is the judgment there?
इसमें रिफर किया हुआ है।
And I shall see. Let us see.
There.
where is LP number 167? Have you annexed the judgment?
Yes, Your Lordship, this is annexure 2, annexure, in the writ petition annexure 2.
एक page,
In the writ petition,
today counter lordship है page 62, annexure A.
No, no, therefore, LPA number 167 also is not bad. It is in line with the judgment of 2012. The only difficulty is that thereafter single judge's orders are being passed and that is being approved. Both the judgments, the division bench judgment of 2012 and this LPA number 167, both say that if the process began before 2000, concluded later, that will not make any difference. They can be isolated into one group where they would be entitled to a higher scale. But, therefore, there is no question of referring the matter to the full bench for reconciliation between two. There are no two divergent opinions. The opinion is same. But single judge's orders, where has he challenged those orders?
Lordship, in the LPL, almost all the judgment has been challenged before this honorable court.
But you are paying them.
Lord,
But you are paying them. So what would you have?
Lordship,
What will you plead in the review petition? I think there is nothing for you to have the judgment in LPA number 167 reviewed. It makes a valid distinction. But you are going beyond that. That is what Mr. Amresh Kumar Singh wants for his clients also. No, we are not satisfied. What would you do to rectify this? We will not pass an order directing the government to give them the scale of 4,000 to 6,000 because we are aware of the judgment in LPA number 167 and another division bench judgment and your resolution. Now sanctioned, the pay which is sanctioned to a particular post has to be given. No matter how much ingenuity we may adopt, we will not be able to carve out any special group for Mr. Amresh Kumar Singh's clients.
Your Lordship, for that purpose, ठीक है, I will assist for Lordship.
We will want the Advocate General to assist us in this matter. Now give us a thoroughly checked affidavit that in all such cases where you are making payment of a higher scale to such employees by virtue of the orders of this court, you have challenged such orders. Otherwise, why should he be kept high and dry? That's the only ground which has emerged today. Yes? Are you in a position to give that affidavit?
those payment is made a conditionally, Lordship.
That's all right. We are not asking you to recover, but then give him conditionally, or you stop making payments of that scale.
In compliance of the writ court order, Lordship, in the contempt, Lordship, and same was paid.
No, you must specify, because review petition is not relevant. There is no fallacy in the orders passed by the division benches. Single judges, I don't know, I mean, we will not go by, all those orders are without jurisdiction. What have you done to rectify that? That is what I want to know. आप बात समझ रहे हैं मिस्टर मदनजीत कुमार? You need not explain. The court has explained the position. We want to know from you what steps are you taking to remove this anomaly. That's all.
Lordship,
Have you challenged all such orders before the competent court?
And your lordship, there is another, your lordship. I
am not inclined to pass any order in your favor for the simple reason that the two division benches are very clear.
हम आ रहे हैं हुजूर कि ये इनका खुद का ये है कि यदि जूनियर को स्केल दिया जा रहा है तो स्टेप करना है, ये इनका प्रोविजन।
तो हम ऐसा करते हैं कि ये सब नोट करते हुए अगर आपके जूनियर को हायर स्केल मिल रहा है तो हम कहेंगे
ये तो हम
सब्जेक्ट टू द रेवोकेशन ऑफ सच ऑर्डर्स।
ये तो हम ठीक है हुजूर, ये कहा है यदि हमारे डिस्ट्रिक्ट में जूनियर को मिल रहा है तो हमको ये ठीक है, हम तो ये लगाए हुए हैं कि जूनियर को मिल रहा है।
बोलिए।
हम अनेक्शर लगाए हुए हैं, अनेक्शर 9 है.
Yes.
सर डिस्ट्रिक्ट्स में जो जूनियर का हैव नॉट वेरीफाइड द फैक्ट सर बट
You don't need to verify every statement made by the petitioner, but
Sir.
you give us an affidavit that persons who don't fall in that category also are being paid or they are not being paid. Tell us.
सर डिस्ट्रिक्ट्स में जो ऑर्डर्स डीईओ के द्वारा पारित किया गया है दैट वाज रॉन्ग इंटरप्रिटेशन ऑफ ए इंस्ट्रक्शन ऑफ द फॉर्मर डायरेक्टर. द डायरेक्टर इंस्ट्रक्टेड द डीईओज टू क्लैरिफाई द पोजीशन बिफोर द कोर्ट and this was taken as a instruction to comply the order.
That's an answer which does not satisfy.
No,
this court.
that is not
As of now, this is the.
That is not correct, Your Lordship. Director was asked to appear. Director appeared, and then Your Lordship, oral undertaking was given. Next date पे implement किया जाएगा.
They heard Mr. Amresh Kumar Singh, learned counsel for the petitioner, and Mr. Madanjit Kumar for the state. As directed by this court, the director. Your director secondary education.
Secondary education.
Director secondary education is present in court. Stop. As noted above, the hard copy of the supplementary counter affidavit, which was earlier filed online, has been filed today across the board, which has been accepted. Stop. The issue at hand is that after the demerger of the cadre of lower division clerk and upper division clerk, only the upper division clerks are entitled to the enhanced salary of 4,000 to 6,000. First off, the grievance of the petitioners in the present case is that persons who are junior to them have been given the higher scale. First off, in the supplementary counter affidavit filed today, it has been clarified that initially the clerks working in the collectorate and other offices who were known as lower division clerks and upper division clerks, initially the clerks were working in the collectorates and other offices as lower division and upper division clerks. Subsequently, with effect from 1/5/1980, under a policy decision of the government, the two cadres of the clerks were merged and they were designated as clerks in the scale of 284/372. About 20 years thereafter, as per the recommendation of the Fitment Committee, a decision was taken by the government by memo number 8825 dated 2012-2000 to demerge the aforesaid two cadres of lower and upper division clerks with a specific pay scale of 3050-4500 and 3050-4500/4590, 3050-4590 and 4,000 to 6,000 respectively. By the aforesaid resolution, it was made very clear that the assistants working prior to the cut-off date of 2012-2000 on the post of upper division clerk, on the merged post of clerk, would be treated as upper division clerk. The post of UDC, upper division clerk, bracket में लिखा है, hereinafter referred to as UDC. The post of UDC was to be treated as a promotional post from the said date. Any vacancy occurring later was also required to be treated to be the post of LDC. There was a further clarification in the aforesaid resolution that in case any process of appointment which had already been initiated on the higher scale of clerk, that would be cancelled with immediate effect, and such candidates who would have applied would be allowed to participate in the selection process on the post of lower level, but without charging them any fee for the same. It has been brought to the notice of this court that in cases of some of the compassionate appointees who were appointed after the cut-off date of 2012-2000, it was ordered by the court in CWJC number 10441 of 2010 bracket Musarrat Ara Khanam and others versus State of Bihar and others, that since the process of appointment had begun before the cut-off date, they would be entitled to the scale of 4,000 to 6,000. No. उल्टा है क्या? आप लिखो पढ़ो. Who were appointed after the cut-off date? नहीं. It was directed by the court.
हुजूर एक मिनट, ये चौथा ऑर्डर आपके सामने नहीं लाए हैं. चौथा ऑर्डर को भी हम दे देते तो अच्छा था. उसका सुप्रीम कोर्ट से फॉर्म हो गया.
It was directed by the court that they were not entitled to the higher scale of 4,000 to 6,000. The aforesaid order passed in CWJC number 10441 of 2010 was upheld in the judgment dated 19/2/2014 in LPA number 100 of 2012. Citations of other cases also have been brought on record by way of supplementary affidavit, in which the same principle was reiterated. Same principle was reiterated. However, in one of the cases, namely in LPA number 167 of 2016, a division bench of this court However, in LPA number 167 of 2016, Avinash Kumar Chakravarti versus the State of Bihar and others versus the State of Bihar and others, a division bench of this court allowed the pay scale of 4,000 to 6,000 to the appellants therein on the ground that the process of appointment had already commenced prior to the cut-off date, and it mattered not if the appointment process got concluded after the cut-off date for the purposes of computing, for the purposes of grant of enhanced salary. Land Council for the State has pointed out that a civil review application, White Civil Review number 236 of 2019, is pending consideration before this court. Be that as it may, Land Council for the petitioner has submitted that notwithstanding the orders passed in LPA number 100 of 2012 referred to above, and a distinction having been made in LPA number 167 of 2016, wherein a special class of persons were identified whose appointment process were begun prior to the cutoff date,
हुजूर एक मिनट आप कुछ बोलेंगे?
but the appointment process got concluded later, comma, some of the persons in various departments were paid the higher scale even though they were appointed later than the cutoff date, and in some of the cases the process of appointment also was begun later than the cutoff date. Mr. Amresh Kumar Singh, Learned Counsel for the petitioner, has therefore asserted that the department has been adopting cherry picking in the matter of grant of higher scale to clerks. It has been lamented by the Learned Counsel for the petitioners that many a times when different benches of this court passes an order for payment of higher salary to even such appointees, of later date than the cutoff date, comma, there is nothing on record to indicate that such orders were contested or were challenged. The presumption of the Learned Counsel for the petitioner therefore is
All
that such orders are collusive and depends and has been depending on the whims and caprices of the authorities in question, of the authorities concerned. Because of such approach of the respondents, comma, an anomaly has crept in the pay structure of all the clerks in the state of Bihar. State of Bihar. Learned Counsel for the petitioner has submitted that many of the assistants / clerks lower, junior to the petitioners have been given the higher scale without any justification. The Director Secondary Education has informed this court, the Director Secondary Education has stated before this court that all such orders passed by the respondents were either by way of obedience to the court's orders or wrong decision making by the district authorities. The resolution of the government of the year 2000 is very clear in its import that only such persons would be granted the scale of upper division clerk whose appointment process began prior to the cutoff date or who had been working on such post prior to the cutoff date. This leaves no room for creating of any group of persons whose appointment process did not begin prior to the cutoff date and who were appointed later than the cutoff date. After having heard the counsel for the parties, the court has a refrain before it. The court is constrained to record that,
Lordship,
yes,
जो भी order, all the order passed by the single judge by this honorable court was challenged before this honorable court in LPF, which is
that's all
pending.
right. We have not said anything of that kind.
Not only
The
also
please don't disturb while the court is dictating.
Lords.
You can tell us after that.
Lords.
क्या लिखा है पढ़िए? The court is constrained to record that in both the LPAs, namely in the judgment of both the LPAs, namely LPA number 100 of 2012 and 167 of 2016, come on, there is no indication of the courts agreeing to the proposition that persons who are appointees of a later date or appointees of a process which began prior to the cutoff, later than the cutoff date, would be entitled to the enhanced pay scale. In that view of the matter, the anomalous situation would not have been, anomalous situation cannot be redeemed merely by preferring a review petition before this court. Review petition before this court. There is no difficulty in identifying a special group of employees who may have the cutoff date, but whose appointment process had begun prior to the cutoff date. This is the widest group under which the benefit of the enhanced scale could have been given. The case of the petitioner does not fall in that group of comprising persons who were appointed prior to the cutoff date or whose process of selection began prior to the cutoff date but concluded later. Hence, this court would find it difficult to allow the prayer of the petitioners.
एक मिनट कुछ कहें हुजूर, ये एक दो जजमेंट दिए हैं, एक जजमेंट हुजूर को नहीं दिए हैं
Why are you in a hurry?
और वो सुप्रीम कोर्ट से फर्म हो गया।
They are not only concluding. क्या लिखा है पढ़िए?
और हुजूर ये जो था कि एलपीए जो 167 में जो था उस आधार पे जजमेंट नहीं हुआ है। 2006 में 300 आदमी को जो 2006 में फ्रेश अपॉइंटी हैं उनको स्केल दिए थे, जिसके आधार पे 167 हुआ।
Just a minute, Mr. Singh, I'm only recording what is in your benefit. Why are you?
नहीं,
Why are you feeling
नहीं,
so jittery?
I am trying to assist you.
Yes. At this stage, merely on the ground that junior persons and later appointees have also been given the enhanced scale, sometimes by the orders passed by this court and sometimes without the shield of the court's orders. The supplementary counter affidavit does explain the position of law, but it does not explain away the circumstances in which persons who are appointees of a later date than the cutoff date have been given the enhanced scale, and the action taken by the the action taken by the respondents in removing such anomaly so that nobody feels dissatisfied with the decision of the government. Mr. Amresh Kumar Singh has pointed out that in several such cases where the enhanced scale has been given to appointees of a later date was challenged before this court without any success, and the matter travelled to Supreme Court, where also the challenge failed. In that view of the matter, there would be two sets of persons with two different salary structure without any explanation. The action of the respondents, to say the least, is geared towards perpetuating this anomalous situation, for which all the stakeholders in the government would be held responsible. To address the aforesaid issue, the court would require the presence of the Chief Secretary on the next date. This court would also require the assistance of the Learned Advocate General, Mr. Madanjit Kumar, Learned GP
20.
GP 20 is requested to intimate the learned Advocate General to be present on the next date. Before parting for today, this court is of the view that it would be in the interest of the government and of the employees that a list be prepared of such cases, of the cases of such employees who have been given higher pay scale under the order, a higher pay scale, even though they are later appointees, even though they are appointees of a later date under the orders of this court. And the cases where such orders have been affirmed by the superior court, a decision would be required, a decision is required to be taken at the governmental level to remove this anomaly. In the absence of such anomaly remaining in the field of payment of salary to the clerks, the court may consider, this court may consider directing for payment of enhanced scale to the petitioners also. After all, the system is accountable to every employee, and it is no justification that in cases of some, a different interpretation and gloss is given over the resolution of the government. Re-notify on. We have said that in this case, in this event, since you have perpetuated this anomaly, we would record all this that it is legally untenable to order for higher scale to the petitioners, but we can't shut our eyes to this fact that many others are being paid by virtue of the orders of this court and others, and therefore whatever you decide later, you make available to them the higher pay scale. Let the Chief Secretary answer to this, and the Advocate General shall also assist. Re-notify on, give a date. I am fixing it sometimes in January. Re-notify on, give a date, give a Friday in the last week of January.
20th of your lordship, last week January में personal difficulty हम
आप जब कहें तब,
उसके पहले जब या जनवरी में
first week of February.
4th of February.
Lordship, one request, Lordship. May additional Chief Secretary will be in place.
We are not concerned. We are not desirous of seeing the faces of secretaries. All that I want to find out is what are they doing about it. We'll say additional Chief Secretary.
Lordship.
Right, additional Chief Secretary. Re-notify on solicitor.
4th February.
Yes.
There are some more cases of identical nature.
Which nature? Which identity?
Same issue.
इसके ऊपर लिखना. The presence of the Director Secondary Education is dispensed with for today. Is dispensed with for today. He would not be required